and welcome to another edition of Litigators Corner. I am fortunate to have with me today Appellate and Trial Lawyer Alan Goldberg. And Alan is going to talk to us today about what every litigator needs to know and has to know if they're going to make a good trial presentation and give the best representation possible to their clients. Alan, how are you today?
Thank you very much, Hillary. It's so nice to be here with you. Looking forward to this.
Me too, and I'm excited to have you here. Alan, tell us about yourself and what you do.
Well, I've been a litigator for 32 years. I've been an appellate lawyer for about 25 of those years. I've conducted about 30 jury trials, and I probably have had about 20 or so appellate cases, all of which have gone to completion. I have 2 published opinions in my name, and I won them both, fortunately. So that sums up my my professional career at this point.
And Alan, you're unique as for most appellate lawyers. A lot of appellate lawyers I know only do appeals. You do both appeals and trials.
I do.
Right?
Yeah, I do. And the reason for that, Hillary, is because I really believe that to be an extraordinary appellate lawyer, one has to be an extraordinary trial lawyer. Because what an appeal is, in essence, is trying to find where the court made an error in the trial. So I believe that if a lawyer has a lot of good trial experience, they'll be more savvy in determining where legal errors took place on behalf of the trial court. Because remember, an appeal is not a second bite at the trial apple. You don't get to retry the case before the Court of Appeal. The reason that a party would go up onto an appeal is because they believe that the court made an error during the course of a trial. So, for example, the party may have wanted to enter a piece of evidence, a document, into evidence, and the court denied that. Or the court allowed the other side to enter a document into evidence to which you or someone else may have objected. Arguably, those are errors in evidence. And those errors could be the basis of an appeal if the client is so inclined to take it up and challenge it. So that's the big difference between a trial and an appeal. A trial is the place where the court will develop the evidence. In other words, the judge or the jury is the trier of fact. They're going to determine what the facts are. The judge is the one who's going to determine what evidence comes in to establish those facts. So if you want to establish a fact and the judge doesn't let your evidence doesn't let your document or witness testify or let the document into evidence, then you may have grounds to go up on appeal by saying that it was an error by the court and that error caused prejudice to my client, and that's why the court should reverse the trial court. The only way that an appeal can be successful is if the appellant shows that the ruling by the trial court was prejudicial to the client. Some errors are harmless, and there's a doctrine called harmless error. It happens a lot. So those kinds of errors would not be the kinds of errors that would go up on appeal. It would have to be an error that truly caused prejudice to the litigant in presenting his or her case.
And I know and this is true for myself, and I'm sure for a lot of other trial lawyers and litigators, the world of appeals seems like a foreign land, and that you hear about, but you're like, well, that doesn't really apply to me. What does every good trial lawyer, in your opinion, Alan, need to know? I mean, even just the basics to make sure that they are doing a competent and not only a competent professional job, but a good job for their client at a minimum, if you had to have that standard.
Yes, it's a very good question. Trial lawyers are the ones who, what we call, develop the record. The record is what takes place in the trial court. The obligation of the trial lawyer is to do what we call preserve the record for appeal. That's the most important thing that a trial lawyer can do, is to preserve the record on appeal. That means, for example, if there is a question that's asked of a witness, and that question is an improper question, and the answer should not be presented to the jury, if it's a jury trial, or to the judge, if it's a bench trial, then the obligation of the trial lawyer is to make an objection to that question. The objection is what preserves the record. If, for example, the question is asked of the witness and the trial attorney does not make an objection and the witness answers the question, the objection is waived. Then the only thing the trial lawyer can do is ask the judge to strike the answer. But a lot of good that's going to do once the jury's already heard the answer.
Right.
Right. So other ways of preserving the record, especially at trial, would be, for example, making sure motions in limine. Those are motions which ask the court to restrict the admission of certain evidence, to make sure that those motions in limine are done meticulously. They're very important. They seem to get a lot of short shrift in trial work, but I believe they're very, very important, because those are the types of motions that keep your evidence out before you get to the jury, and then the jury doesn't hear you arguing with the judge about why that piece of evidence should have come in, which could influence how the jury feels about the lawyer or the lawyer's client. Motions in limine should be very meticulously done, and everything that needs to be put in them should be put in them. So those are two examples of how we preserve the record.
For motion in limine, I agree, that's often an essential and overlooked part of practice. And it's been my experience, if you bring this up in motions in limine and some of the issues, even if you lose or you don't get your answer, judges tend to be more sensitive to that issue when they hear an objection going into trial.
I agree with that. Yes, they could deny the motion in limine because they just want to see what's going to happen in the trial and how the trial pans out, so to speak. And then they could grant you your objection. But of course, at that point, it's incumbent on the trial court to make sure the objection is made prior to the witness giving the testimony or the document being shown to the jury. So then you're back in the same position of being astute, on your toes, and making sure that your objection is made immediately.
Right.
You know, I'm the kind of lawyer that I'm jumping up and down in my seat, waving my hands when I'm getting ready to make an objection. The judge knows when I'm getting ready to make an objection.
There's no question you're coming.
No question.
No, and that's good, so it doesn't sneak up on you. And I know that, do you recommend with any hearing on a motion in limine that it's also on the record?
Absolutely. In my opinion, Hillary, everything should be on the record. That includes conversations at sidebar. Nowadays, they have remote capability of the court reporter transcribing what takes place at sidebar, so the court reporter doesn't have to get up and bring the dictation machine over to the sidebar to hear everything. That's a very good thing, because now conversations at sidebar can be on the record. I also highly recommend that if the judge invites counsel into chambers, that counsel invite the court reporter in also, because even chambers conferences should be on the record. Oftentimes things take place in chambers that if it's not on the record, you wish it was.
No,
and then if it's not on the record, it didn't happen, correct? Yeah.
What would you say to a client that you're discussing trial strategy with, and the importance of a court reporter, and maybe getting someone like you involved earlier on to prepare, and they look at the expense of it? I mean, that's usually the first thing they look at. Well, I don't know if I want to pay for a court reporter. I've already paid you X amount of money. What would you say to, other than the obvious that you don't want to get sued and hey, what would you say to them? It's
a very good question. If the value of the case is low, I mean, keep in mind that a court reporter for a typical hearing, and I'm talking about on any kind of a motion, would be somewhere between $700, $800, $900 for a typical hearing. If the importance to the client on winning that motion, and if they don't win, having a record to take up on appeal is worth more to them than the $900 or so that it would cost for the court reporter, I would say definitely. If you're talking about a $5 million case, I would have a court reporter at every proceeding. If it's a small case and the client doesn't want to pay for a court reporter, that would be the client's decision. I personally would recommend that there be a court reporter at all proceedings in the event that the case needs to go up on appeal or on a writ, especially on a writ. Sometimes you have something that happens at a hearing. Judge makes a ruling on a hearing. For example, the judge makes a ruling and grants the plaintiff a writ of attachment. Now the plaintiff can go and attach all of the defendant's property. The defendant may say, well, that was really improper. For example, the plaintiff could be secured with a deed of trust on a piece of property, which covers the amount of the debt, but the court issues the writ of attachment anyway. It happens. Mm-hmm. If you don't have a transcript on a writ of mandamus, you can include a declaration, but if you have a transcript, you've got a much cleaner record. You've got a technically perfect record, and that's what I would suggest that you do if you have to go up on a writ. If you have to go up on a straight court of appeal, you don't get the luxury of submitting the declaration, so you lose out on the transcript, which on appeal is called a reporter's transcript. You lose out on that, which is a problem. Can be a problem. It's not always a problem, but it can be.
And I know that we've talked about approaching the court when you feel at trial that their ruling is in error, or they may not have maybe didn't read my brief. What are some ways that you can approach a judge? Because we all have feelings, egos, ways they want to do something. Maybe the judge has had it with this case and it's been on their docket for 3 years and they're tired of each motion that is coming in. And, you can usually, a sensitive lawyer can usually get a sense of, okay, the judge is really fed up with this and not happy. The judge wants to hear this. What are some of the ways that you recommend, Alan, that you can tactfully approach the court without offend? I mean, while asserting your rights, sometimes you just have to make the judge mad. We've all been there. But other times there are ways to do it where just, all right, it's reasonable. Ms. Johns or Mr. Goldberg needs to do this for their client. I understand. But, we've all seen it. Judges are mad. They're not happy at all. Maybe it has nothing to do with us. But you can tell when judges usually are not happy with the litigants. And if you have a situation like this, how you handle a situation can make a huge difference in their rulings. What would you recommend?
I have had cases, and I admit, fortunately, not very many, but a handful over my career where I am certain the judge did not read the papers. That happens for whatever reason. I don't think it's necessarily because they're bad judges. They probably were just overwhelmed and they couldn't get to it. So what I do in a case like that is, number one, never, ever accuse the judge of not having read the papers. I have seen litigants do that. And if you want to make the judge upset, that's definitely a good way to start.
Or any lawyer for that matter.
Absolutely. What I do in those situations is I will say, well, Your Honor, at page 4, line 13, we argued this. And then I'll say on page 7, we argued this. This way, even though the judge may not have read the brief, I'm telling the judge exactly where the arguments that I'm trying to make are found in the briefs, so the judge knows that they are already in there. It does happen. And as far as getting the judge upset, you are so right. I don't think there's any lawyer who's done more than a handful of trials that's never gotten the judge upset. They get tired. Everybody gets tired. And here I am arguing that, this thing happened or that thing happened and you need to correct that. Yeah, it's minutia. But that's how you preserve the record. And despite the fact that the judge may not be very happy about going on with this, you don't have any choice. You have to do it.
And most professional judges want to do the right thing and to do a good job. And they know what the reality is. That's what they're paid to do. And sometimes being a judge is not an easy job. I wouldn't want it. I wouldn't want to do it.
Being a judge is definitely not an easy job. And yes, most of the judges that I've encountered over my career have been upstanding, wonderful, professional. I have had a few judges that either didn't like my client or were just in a bad mood. It has happened. It doesn't happen often, fortunately, but I can't say that I have a great complaint about judges having an attitude, because honestly, I have not found that to be true.
Yeah, and I think that's true of most. I'd like to think that's true, and that's been my experience of most of the judiciary. In a situation where the judge has made an adverse ruling, and you ask them something and they say, counsel, I've already ruled. What would you do in a situation like that before the jury? I'm assuming the jury's not there at the moment.
Yeah.
But if the jury is not there, what would you do?
You can't beat it to death before the judge at that time. The only thing you can do then is you can wait until the jury is not present, or at the end of the trial, and you can say that, Your Honor, I'd like to revisit this ruling that you made at this time on this issue. But once you make your objection, and if the judge overrules the objection, the only thing you can do at that point is ask for a sidebar to try to explain to the judge what the problem is. And this is a big problem when we have judges who don't want speaking objections. In other words, where they don't want you to say objection and then give the reason for the objection, which I find to be very stifling in trial, because to just say objection, the judge doesn't necessarily know what I'm thinking, and I certainly don't know what the judge is thinking. And if they overrule, I don't know if they have my idea in their mind. So I have a problem with that going into it. And at the beginning of trial, I always ask the judge, Your Honor, do you accept speaking objections where I can say objection and then give you the reason? If they say no, then I'll try to get them to say, in this case, would you allow it? And sometimes they do and sometimes they don't. But if they don't, if they overrule your objection and it's a critical issue, I would ask for a sidebar and make sure that the court reporter is present either electronically or physically.
And do you usually, I've had that very situation. There are some judges who just have it in their pretrial orders, no speaking objections. Just tell me what it is. I just don't want it. I don't need to hear the argument. And, and some of them, it depends on the situation too. I've had situations say, Your Honor, we may revisit that after the jury's excused or something. And usually, at a minimum, the judge respects that you respect the bench, you respect the rule, you respect the robe, and that you're not trying to unreasonably interfere with the proceedings. But there's an issue that needs to be addressed, and maybe they need to mull that over another day.
Absolutely, you have to always give great deference and respect to the bench. Not just because of the stature of the judge, which is a very good reason, but also in the eyes of the jury. You want the judge to be respected by the jury, and you want the jury to respect the lawyer in his or her interactions with the judge. It's important that that respect be given even in an adverse ruling.
And what other tips would you have for a person who's going into trial and they say, I got to get on the ball with this. I need to know what I have to have covered. Maybe this is going to go to appeal, maybe it isn't. And I'm sitting in a situation where the trial attorney or the litigator has not had the benefit of retaining someone like you to advise them throughout litigation. So you're going into trial, you got to preserve the record. What are the main points that you've absolutely got to have to do your job, just even competently, let alone really well?
You have to be prepared for all of the nuances in the case. That's critical. Every case has nuances that, unless you've gone through the record meticulously with a fine-tooth comb at least once or twice and discussed it with the client ad nauseum, you need to have those nuances, because those nuances often make or break the case. Another thing you should do is on motions, you have to make sure, especially on motions for summary judgment, you have to make sure that every piece of evidence, whether it's a transcript or a document, is submitted to the court, and that all of the facts are stated in the separate statement of facts, because anything that's not in that separate statement of facts is not going to be evidence, and you have no argument after that in the Court of Appeal. So make sure your separate statement of facts is meticulous. I always say put more in, put as much in as, even if it belabors the point to some degree, because you never know what nuance is going to be the issue on which that case turns. So I tend to put in the nuances that I think will fill in that blank that we don't know. Be meticulous on jury instructions. I mean, jury instructions are critical. You have to not only review the opposing party's jury instructions and make sure that there is nothing objectionable in them, especially as to special jury instructions. You have to make sure you check the statute they're citing, make sure you check the case that they're citing. I have seen so many times when the opposing party cites to a case and the case really doesn't say what they say it says. That happens a lot. And as to one's own jury instructions, again, be meticulous. Make sure everything that could possibly be an issue in the case is covered by a jury instruction. And then we discussed motions in limine earlier. We discussed preserving the record with objections earlier. All of those things go to the critical components of preserving the record. If the case is a large case, it really is a good idea to consult with an appellate lawyer to make sure that the outline of what needs to be done is followed. If it's a small case, that would be the discretion between the client and the lawyer as to whether they want to put the money into it or not. But on valuable cases, it's a really good idea.
Or if there's insurance coverage, that's something, for example, it's going to be covered. And I was getting back to I agree with you and I always err on the side of being overly comprehensive, overly thorough. And what I often find just for myself, and I certainly tell my clients, is we don't always know what the decision maker is going to think is an important fact. Just because I think it's an important fact does not mean that the judge is going to agree, or as importantly, the jury will agree, or something you think is the winning point. But there may be something else in your presentation that they pick up on. They go, no, I don't care about any of that. But I did see this right here. That happens, in your experience, that happens to me a lot. And so in your experience, is that something that frequently occurs or does happen?
That definitely happens. And that's why I was suggesting earlier that when you do your separate statement of facts in a motion for summary judgment, or when you do your motions in limine, or you write your motions, put in those nuances, because one never knows what nuance the judges or the trier of fact, the jury, is going to pick up on as the critical fact that makes or breaks your case. I had a case one time in which I had a client whose driver's license was from another country. The opposing counsel never made an issue of the legitimacy of the driver's license, yet I won the trial on 11-1 jury because one juror decided on his own that he wasn't sure the license was a legitimate license. You never know where the critical issue is going to be. Fortunately, I won the case, but I could have had a unanimous jury.
or the fact that persuades them, okay, I like your case better. Sometimes
Absolutely.
A winning point, but it's like, after I heard that, I started thinking about the other stuff. You're probably right. That's often what happens, or they go, after I heard that statement, I'm not going to rule in that favor. Sometimes I've had it happen where you just, it's not going to go. They're not going to rule in your favor. You're going to have to do it some other way.
Oftentimes when I'm writing briefs or when I'm writing motions or even when I'm arguing, often I repeat myself. I don't do it a lot. But if it's a critical point, a critical fact, whether it's in the trial court or the court of appeal, I will repeat the critical fact at least 2 or 3 times to make sure that if it's in the court of appeal, all 3 justices have registered it. And if it's in the trial court, that the judge and the jury have registered it also. I think that's an important way also of preserving the record, and also convincing the jury of the legitimacy of one's case.
No, it's true. And I don't know if I always liken it to little snippets, or if you've ever had the TV on during an ad and you mute it, if you have the lights out, like in the evening, if you see how many images are flashing at you the entire time and how many times they repeat something in an ad, I sort of tell them it's not completely subliminal, and you don't have to beat a dead horse, but as many times as you can put it in, the jury starts thinking, I heard that, I don't remember where. Did I hear from counsel? They start to think more about it the more you repeat it, and not saying, and sometimes I think it is okay to say, if you remember nothing else from today, remember this. But it's, that's the very obvious, clear part. But even that, you don't always know what we're going to say, what the judge or the jury is going to hear. And everybody has their own inherent biases and way, and even if it's not a bias, way of seeing things. But it makes a huge difference in presentation and preserving the record for appeal.
I totally agree.
If you're, what else would you tell a litigator if they're heading towards the end of the trial? Maybe that, we talked about two ways. You're either gonna win or you're gonna lose. The jury just says we have no idea and we can't. Rarely is it going to happen in a civil case where they're not going to make a decision. In a criminal trial, it's a different matter. It could be a mistrial. But assuming there's no mistrial or other issue, and you want to preserve your record, there are different approaches I think you take. Would you take a different approach, I guess is my question, if you thought you were going to win or going to lose?
Different approach as to how I deal with preserving the record?
Yes.
As preserving the record, no. I will preserve even if I believe I'm on a path to victory, it would not be appropriate and it would not be a good service to my client for me to let up on preserving the record. So even though I know that the judge probably feels the same way I do, that it's not looking good for the other side, I am still going to make my objections, and if I'm allowed to argue them, I will do speaking objections because, again, everybody who's litigated a case knows that you never know what a trier of fact is going to do. You may have a good feeling about it, but you really don't know. So you have to take the approach that, yeah, I'm feeling good about this case, but I'm not letting up now because I just don't know what's going to happen between now and the time the judge charges the jury and sends them off to the jury room. So yes, I continue to be meticulous about everything.
If you were going into someone who's going to trial, maybe they've had bigger cases, but maybe they just haven't done a lot of appellate things for whatever reason, and you're going in and you've got to preserve this record for appeal. This is just too important a case not to do it. What if nothing? Once trial starts going and things start flying through the air and there's objections and your client needs hand holding and there's witnesses and one doesn't show up and you've got to go find it, whatever's going on. What, if nothing else, are a few things that you've got to remember as a trial lawyer to get that record done?
That's also a very good question. I am the kind of attorney that when I have witnesses who are not part of, for example, my client's close friends or family whom I plan on calling as witnesses, and I'm certain they're going to show up to trial. So if I have to call someone else, whether it's a professional in some other field or it's a witness who is not known to my client, even if they're favorable witnesses, I subpoena them. I subpoena my own witnesses. Now, I don't serve them. I call them and I say, hey, we got trial coming up. I've got a subpoena. I need to give you a subpoena for the trial. Will you accept it? I do this, or I may do this on email also. If I do it on the phone, I'll confirm it in an email. Otherwise, I'll just do it in an email. And then will you accept a subpoena by regular mail? Or will you accept the subpoena by email? This way, if you have a critical witness who's not familiar with your client and will be voluntarily happy to come to the trial, you may have a reluctant witness, even though they're a favorable witness. Get them under subpoena, however you do it, whether it's informally or formally, get them under subpoena, because then if they don't show up, you've got grounds to ask the court to either issue a bench warrant or a mistrial or a postponement of the trial until we can get that witness there. But if you don't have them under subpoena, you lose. That witness doesn't show up.
And there are some, and what would you say to, and I've had this happen, I'm sure you have, but they say, oh no, such and such is a friend, or, don't subpoena them. I don't want them to feel bad. Usually I would say something like, look, there's the obvious that we really need to ensure they show up for this. But also you can say, look, it gives them a reason to show up. They're not going to have to explain it to their work,
exactly,
to their friends, to the opposing party. If it's a company, they don't have to explain to the other direction, look, I'm under subpoena, I have to go. So often it does, I don't know how you feel about it, I tend to explain it like this is actually more beneficial for this witness because it protects them too.
I totally agree with that. And that is definitely another reason why it's a preferable procedure. With respect to a witness who is assuring me they'll show up, I would look, my client is my boss. So I would bring this up with the client and I would say, this witness is assuring me they'll show up. Here are the benefits and the downside of subpoena. Sometimes people get upset if they're subpoenaed. It does happen. So you could actually have a reluctant witness if you subpoena them. That all has to be discussed with the client. The client is the one who makes the decision on the advice of counsel. So I have to make sure the client understands both sides of the benefits of subpoenaing a favorable witness and the downside of subpoenaing a favorable witness. And then I let the client make the decision and either get a signed agreement by the client or make sure everything is confirmed in an email. But there should be some writing. If this is a critical witness and the lawyer is not sure that this witness is reliable enough to show up, the client makes the decision, make sure there's a record of it. Like everything else, you have to make a record.
No, exactly.
Yeah.
Going into trial and you're finishing up, what if you feel you've missed something? What if you feel the record isn't clear on an issue? How would you revisit that tactfully without one making the judge say, hey, counsel, move on. We've already talked about this. No, we're not doing that today. Or the jury going, didn't we already talk about this? And I want to go home and I got to get back. I've been here 5 or 6 days. And how long is this going to be? And, you know, because that's going to start to happen. You're just not going to hold their attention that long, just even in the best of circumstances.
I agree. It does happen. And what I would do is I would not bring it up to the judge in front of the jury. What I would do is I would wait for the judge to have a break. And then I would say, Your Honor, I've got a procedural issue that I would like to discuss with you. Make sure the court reporter is present. And then ask the judge for leave to do whatever it is that should have been done earlier to do it at this point. If the jury doesn't know that something is being tacked on, it's not going to affect them one way or the other. They'll just think this is part of the trial. But if the issue is raised in front of the jury, then the reaction that you just displayed could certainly happen, and you want to try to avoid that.
And what if you can't avoid it? What the judge says, counsel, look, we've had all the rulings. No.
Right.
And you're going to end up with me after in the jury. If I think it's important, I'll call him back, but I've had it. I'm done. You guys, I'm tired of it. Really. No.
Yep.
And what do you do then?
Then as long as you've made a record, then you have grounds for the judge denying you the opportunity to present your case fully, which every litigant has a right to do. You've got due process issues there. There's also California public policy, which says that all cases should be decided on the merits. If the judge doesn't allow the litigant to present the merits, it's arguably reversible error. And the judge could then be back with a whole new trial and a new jury on the issues that he or she could have avoided if the judge just let the counsel present, whether it was one witness or one document or what have you. So I would say that would be good grounds to go up on an appeal.
But there are ways to tactfully say most judges don't want to hear. That's grounds for appeal. That's reversible error, Your Honor. Most judges say, Your Honor, there's this. And how would you phrase this? What are some ways to tactfully phrase that? I mean, no judge wants to be confronted like that. Say, like, counsel, I'm not stupid. I get this. I'm not my first rodeo here. Come on. But there's ways to say it without saying. All judges know if they lose, they can be appealed, and no judge wants that.
Right. I would never do that. I would never threaten a judge with an appeal. Now, I have been in a situation more than once where, especially on motions, where the judge is not making the right decision, and I ask the court for a stay of enforcement of the ruling to take a writ of mandate, a writ of mandamus. I have been in that position before. That's not telling the judge, it's not a threat. That's asking the judge for a procedural remedy for the purpose of trying to rectify whatever it is that I've perceived as incorrect. I don't think that's a slight to the judge as much as if I were to say to the judge, well, Your Honor, if you don't give me this, I'm going up on an appeal. I would never do that. I would never even look like I'm threatening the judge with anything, even though the judge knows that I'm probably going to go up on appeal. I would never bring it up like that. What I would do is I would say, Your Honor, I need to make the record complete. Your Honor, I would like to have Your Honor decide this case on all the merits, all the facts, and I would appreciate it if you would give me leave to call this witness or introduce this document or whatever the issue is. I would do it just like that, and I would make sure I have a court reporter present.
What else would you tell someone that's finishing up a trial? and they want to make sure everything's covered. Is there like a list? I usually have like a list that I go through, and then I usually am fortunate enough to have awesome staff that I can talk to and say, hey, did I miss anything? Is there something I need to cover? Did I tell you guys anything else? And I talk to the client too, of course.
Exactly.
Ask them and say, how do you feel about this? Do you feel that you're being portrayed in the best light? Is there something that you think needs to be made more clear?
That's exactly what I would do. There are two ways that I answer that question. Number one, I do also have an outline, and I make sure that my outline contains all the critical points that I need to make in order to make my case. And then I am always asking the client, is there anything else that you want the judge to know? And if the client says no, all my witnesses and I have said everything we need to say, then I know the trial is complete. If the client says, I would really like to the judge to know this or that, that's when I would ask the judge for leave to present whatever that evidence is. Now, keep in mind, you don't wait to discuss this with your client till the end of the trial. You're discussing this with your client all the way through. So for each witness that goes up, I would say to my client, anything else you want this witness to say? Anything else that needs to come out? Any other documents that you want this witness to identify? Did we cover it completely? So you're doing this throughout the entire trial. But at the very end, the general question would be, did you get into evidence? Did you tell the judge everything you want the judge to know, or the jury, before they make a decision? That's what I would do at the end of the trial.
I always tell myself it's not about me at all. It's about my client and being in the courtroom with really where you're a guest and inviting these other people, and the jurors are giving up their valuable time. So I try to look at it from all angles or all approaches. I mean, I don't know everything and I don't know what everybody's thinking, but I think that's a good lesson and a good way to proceed, and just having that kind of perspective about it, because I see so often that lawyers get bogged down or they get caught up and just, I got to get this and I got to get this. And, okay, good. I've made my presentation. It's like, okay, well, just because you think it's a good presentation, what about everybody else in the room?
True. And it is, I agree with you. It's not about the lawyer. As long as the lawyer doesn't do anything to cause aspersions to cast aspersions on the client. So the lawyer has to be on his or her best behavior. You don't want to get any jurors to think, negatively about the lawyer. You want everybody to like you, which is hard to do sometimes, but that's what you want. You want to be sort of in the shadows, but not quite, because you're the one who's presenting the case for the client. So you want to be in a position where the jurors are paying attention to you. You want to catch jurors. You want to look at them in their eye. You want to go from juror to juror and speak to them personally. You want them to respect you. You want them to like you. But you're right. You can't be the star attraction of the trial, because your client is the star attraction of the trial.
Unless it's maybe some exception where your client isn't particularly likable and maybe you want to take attention off. But that's probably a subject for another presentation.
It's so true. It's so true.
Alan, what parting words do you have for us and all of our viewers?
Okay, my parting words would be, if a person is seriously considering an appeal, in California, the rules that are governing the appeal are California Rules of Court number 8. That's where everything is. If you want to know what you have to do and how to do it, go to Rule 8 of the California Rules of Court, and you will find all the information you need there. Now, there, of course, there's case law which interprets those rules, and you can always look those up after you've read the rule, but that's the place to begin. So in summary, preserve the record, make sure you get all your objections in, and if you're going up on appeal, either hire somebody who knows an appeal or be very, very familiar with Rule 8. That would be my suggestion.
Alan, this is always so interesting and informative. I know that we often have conversations that go on for substantial periods of time, which we won't bore our viewers with, but Alan is not only an excellent lawyer, but a very fascinating person. And I think that we could all benefit from his wisdom that he shared with us today. Alan, thank you so much.
Hillary, thank you so much. This has been a real pleasure.